A little too excited. I've been asked by Trevor to introduce him. He's a man that doesn't really need much introduction. He makes his presence known. This is a good thing. But Trevor Todd is a really experienced trial lawyer, former president of the Trial Lawyers Association in 1987. He's been practicing law for over 40 years, and he's been specializing in estate litigation for a very long time now. He practices under the name of disinherited.com, which is his website, and he blogs frequently. And I commend you to visiting his blog, where he keeps it updated, and he's blogged extensively on WESA, so there's a dearth of knowledge there for you to gain. Today he'll be speaking on a subject that's very near and dear to his heart, undue influence, and the change that he actually helped to the change to the Act, the change to the body of law that he actually worked very hard at promoting and to get it into the Act in the first place. So, with that.
Thank you, Candice. And I did save the only sexy topic of the day for myself. I have a real interest in undue influence, and I always have, but unfortunately the law has precluded me from bringing many actions to trial in about the last 20 years due to the risk of special costs. Might I just take a straw poll here? Who has actually taken an undue influence case to trial? The Clark Wilson group, of course. And how about taking a will case to trial based on undue influence? 2, 3. And of those 2 and 3, who won? 2, 3. Okay. So we're all winners here in estate litigation, but the last undue influence case I did was 1994. And I had a will set aside. It's on my website. It's called Hicks versus Hicks, and it was upheld by the Court of Appeal. And the judge, Justice Shaw, found strictly undue influence, and it's a good decision. But at that point, the courts hadn't come along with slapping on the wrist with special costs if you failed to prove undue influence. That happened just almost immediately thereafter. And that has put a real wet blanket on anyone bringing a claim for undue influence, because the law with respect to wills has, for about 25 years now, since the worst case ever decided, Vote versus Hay, in my opinion, our esteemed Supreme Court of Canada, Mr. Justice Sapinka wrote the reasons for judgments, and it was a 7-zip decision that when it came to undue influence on a will, you had to prove it. You have to, the propounder of the will has a benefit of a presumption of capacity once knowledge and approval is assigned, and the attacker who's alleging undue influence has to prove it, which is darn near impossible if you think about it, because of the very nature of undue influence. It's usually done in secret, unless you're a cult. A cult is about the only public group that I can think of where there's undue influence and it's blatant. But I have never had a cult case. But if you ever do, and I know David had a semi-cult case, a spiritual leader in a certain community was taking advantage of his position, so to speak, and he won on undue influence in that case. But again, that was some time ago as well. So it's been highly, highly risky to bring us undue influence cases with respect to wills now for about the last 20 years. And that's probably why most of you didn't put your hands up. You've all probably alleged it, but not actually gone to trial on the undue influence, because the costs are considerable if you lose. Special costs can easily be $100,000 or more, and it just hasn't been worth it. So what you'll see in the materials are 2 papers. The one I'd like to refer to the most is one that was done in 2006. Judith Milliken QC and myself submitted this document, which I just happened to find, 8 years later. And this was our submission to the BC Law Institute in response to a request to make a submission with respect to undue influence. I don't think very many, if anyone, did, other than ourselves. I certainly didn't hear about it. I raised the matter at the Wills and Trusts subsection meeting, and we had about a 5-minute debate about it. I said that why should there be a difference in undue influence with respect to inter vivos gifts, which is the Geffen case in the Supreme Court of Canada, you'll see in my materials. There, for 20 years now, there's been a presumption of undue influence when there's been an inter vivos gift made to a person in a position of domination. But that isn't the law and hasn't been the law with respect to wills. And why would there possibly be such a difference? Because the presumption is everything. It really is a huge leg up in this area of the law. So I'm very, very pleased to see that Section 52 has been brought into WESA, and it, by and large, makes it a level playing field now with respect to the undue influence, that where there's either an inter vivos gift or a will, leaving a substantial bequest to a person who's in a dominant position, such as a caregiver, that there's now a presumption of undue influence. Now, there's still going to be special costs, I submit, if you lose, but it gives you a presumption. It gives you a great leg up, and that's a huge factor when it comes to undue influence. So I'm very pleased to see that our submissions were accepted more or less holus bolus, and Section 52 was brought into effect. I just wanted to give some background to WESA to show that these remarkable changes in legislation that have been in effect, they've been working on it for 30 years. That's when they started. I think most of the big work was done in the early 2000s. I spent a good part of 2005 fighting the changes to the Wills Variation Act. Now, I have a bit of a bias here, but I am convinced that the major aspect of WESA was to change the Wills Variation Act. That was the initial legislation, and it was going to do away with the right of an adult independent child to challenge a will. And the reason for that was that BC is the only province in Canada that allows that, and therefore that we should conform with the rest of Canada, which I thought was just nonsense. And Judith and I made a number of written submissions to the Attorney General, and I think Mr. Justice Opal, later to be the Attorney General at the time, would be the first to tell you, as he's told many others, that it was basically him versus the Cabinet when it came to the Wills Variation changes. And very fortunately for, well, I'd say us, but certainly my practice, Justice Opal was upheld. And his rationalization is that if we bring in the changes that are sought by WESA to the Wills Variation Act, all of the, quote, brown girls will get disinherited and not have any rights to contest the will. So that was our hook with him, and it worked, fortunately, but by our chinny chin chin, because if going back to 2005, it was more or less announced that this was going to be the change in the law, that an adult child will no longer have the right to contest a will. It was vigorously fought. I went to the three major bar meetings in the province, Vancouver, Kelowna, and Victoria. We had vigorous debates. I suggest to you, if you want to ever have a lively dinner party, just raise the Wills Variation Act as a topic. And it's like talking about religion or politics. You'll get into an argument. It's a philosophical matter, but I'm pleased to say that that's gone by the boards. The Act has largely stood in place. And no sooner had that been decided than BCLI, the BC Law Institute, put out a request to make submissions on undue influence. Judith and I jumped at that chance. I really don't think the rest of the profession had much to care or concern about it, because when I raised it at the Wills and Trust subsection meeting, we had about a 5-minute debate, as I said. I pointed out the discrepancies between the inter vivos gifts and wills, and why should there be any difference whatsoever. My learned friend representing the forces of darkness argued floodgates of litigation, at which point I knew we had him win. If you're resorting to floodgates of litigation, that's just a nonsense argument as far as I'm concerned. So Section 52 of the WESA legislation is a tremendous leg up for plaintiffs' counsel. I'm personally delighted. I think we're going to see more and more undue influence cases now brought successfully to court challenging wills. Now, the paper that was submitted in 2006 is basically the background of the law of wills, of undue influence as it existed in 2006, which really hasn't changed at all until March 31st of this year, when Section 52 came into effect. Just going through the paper entitled Shine the Light on Undue Influence and Protect Elders, the first page talks about the fiduciary relationships. And fiduciary relationships, as we all know, can be anybody from a lawyer and a doctor, but it can also be a caregiver. It can be any number of people in their positions of vulnerability or reliance, and it gives rise to this fiduciary relationship. And certainly with respect to undue influence, I'm relating it to a vulnerable person being taken care of by a dominant person. Let's take the caregiver situation, whether it be a child, a hired caregiver, a third party, a family member, it doesn't matter. In my experience, anyone who's inherited significantly under a will always admit that they deserve it, that they expected it, and in fact, after all what they did for the deceased, is that all they're getting? So I find it's very easy to lead someone down the garden path, so to speak, to get them to admit that they took their parent to the doctor's appointments and they bathed them and they fed them and they did all the caregiver sorts of things. Most people will willingly admit all that and then some, thinking that they justified the inheritance. In fact, they're playing right into our trap, that where there's a will or an inter vivos gift, if they're admitting that all those things that they did, they're admitting that they were in a position of domination and that the vulnerable person was in a position of weakness, and therefore there's a presumption of undue influence and the onus of proof shifts. And that's a big, big factor. Because the difficulty with undue influence has always been that it's not just influence, it's not just persuasion, it has to be coercion. Now, coercion is almost tantamount to duress. It's not quite duress, but it might as well be. So the law for many, many years is if you're going to have to prove undue influence, you have to show that the coercion was to the extent that the will maker or inter vivos grantor, I should say, this was not my wish, but I must do it. The person has control over the other party's mind. Now, typically there's often dementia, but there doesn't have to be dementia for there to be undue influence. And I'll use the cult example as a good example. You can join my cult. All you have to do is give me all your assets and have sex with me whenever I want. Sounds like a good deal? Okay. You're in my cult, and I now control your mind. And this is what happens. We read about it, and people give away all their assets. I mean, the bag one down in around the Portland area about 20 years ago. Sorry? Okay, you were there. Yeah. He had 68 Rolls Royces, I mean, meanwhile, everybody's working as a slave, and he's having sex with them whenever he wants. And there were some undue influence cases. Did you bring an undue influence case around? okay, yeah. When you got out? Yeah. Now, as I said, I don't see a lot of cult cases, but that's a good example of somebody where there's not dementia, but you can still be under the control of somebody else's mind. That happens quite often, actually. Ask any husband. There's two kinds of undue influence. There's the actual and presumed. Now, actual you have to show the coercion. The presumed is really what I'm talking about today. The presumed undue influence is where there's a relation of trust and confidence between the transfer and transferee, or that creates this rebuttable presumption. Same with the caregiver situation. It's the position of relationship of trust between them that gives rise to the presumption. But the problem with claiming undue influence, and the reason that special costs are awarded if you fail to prove it, is that undue influence is actually civil fraud. You're alleging fraud. And for many, many, many years, when you allege fraud, you are doing so at your own risk, and you'd better prove it because the law will come down heavy on you with respect to special costs. So our submission back in 2006 was this is a ridiculous distinction between inter vivos gifts and wills. We related some of the law relating to the law as it was back then. And I quote Justice Sigurdsson in a case of Oroju and Nito, where he neatly summarized the law of undue influence in 2001. And basically said, the onus for proving undue influence for inter vivos gift differs depending on the nature of the relationship between the parties. In the absence of a fiduciary or special relationship, the onus rests on the party alleging undue influence to prove it. However, undue influence is presumed to apply to certain relationships or in certain circumstances, and the onus shifts to the recipient of the gift to rebut it. So he was talking about gifts, and he was following the Supreme Court of Canada case of Goodman Estate versus Geffen, which is 1991, which happened I think it was 4 years after this terrible decision of Vogt versus Hay. No, pardon me, that was 1995. Vogt came after Geffen, which that's right, it particularly confused me because the Supreme Court of Canada firstly said in 1991 that yes, there is this presumption of undue influence for inter vivos gifts where there's a position of a fiduciary relationship or domination in a vulnerable person. But then 4 years later, in Vogt versus Hay, they said 7-zip, no, there's no presumption to wills. You have to prove it. Now, the facts on Vogt and Hay themselves send me somewhat ballistic. Hay's 81. He's murdered. He leaves his estate entirely to a 24-year-old lady who had her friend, the legal secretary, prepare the will based on a phone call she says came from the deceased, and the young lady paid for the bill. Stinks to high hell. Supreme Court of Canada, 7-zip. No, you didn't prove undue influence. You have to prove it. Sure, it's suspicious, but it's just suspicious. And they deal with suspicious circumstances and say, yeah, sure, there's suspicious circumstances, but that's just an evidentiary matter. You still have to prove it. Now, I set out some quotes from Vogt and Hay, which I think we can hopefully largely ignore now, at least with respect to caregivers. It's still the law for third parties, but caregivers and people in positions of domination and vulnerability, it occurs very frequently in my experience. So with suspicious circumstances, I've listed about 17 examples of it on page 10 of my paper. There's many, many, many more suspicious circumstances. My paper wasn't on suspicious circumstances. I'm just giving these as examples that the courts would look at, and it's everything from addiction to drugs to just being elderly to being changing radical wills one after the other to getting out of the hospital, hasty marriages and hasty this and secrecy and all the things that all us estate litigators deal with on a daily basis. Those are just suspicious circumstances, but they didn't really amount to a heck of a lot in terms of having to prove the will. So the onus of proof then with the shift to the presumption of undue influence shifts the onus, of course, and it's a rebuttable presumption. So if you've got a child who's stayed at home all their lives and cares for mom and dad until his dying days and inherits, I don't think there's going to be any problem whatsoever in rebutting the presumption. It's an evidentiary matter. But on the other hand, if the will is left entirely to the caregiving neighbor who shows up late in life and cuts the lawn and does a few trips to the doctor and all the usual things we hear about, then I think there is a presumption of undue influence, and I doubt very much that the evidentiary evidence there would be sufficient to rebut the presumption, and I think we'd then have a winning case of the will being set aside. So that is what I'm very, very optimistic about in terms of, it's like Justin Timberlake said, we're bringing sexy back, we're bringing the will's variation back, we're bringing undue influence back. And so my second paper is the short one with the kindly nurse having her arm around the lady signing the document. And it specifically relates to Section 52. I've given you the background, how it got there. Just didn't materialize out of anywhere. People made submissions. We argued these things. It seems so long ago now. It was a long time ago. And it's finally here. And Section 52 creates a presumption of undue influence where certain types of relationships exist, which are typically those of the will maker being in a position of dependence or submission to another person, often a caregiver. Once that relation of dependence on another person is established, the party defending the will's validity then has the burden to prove that he or she did not exercise undue influence over the will maker. That's huge. Undue influence is nearly always done in secrecy. It's behind closed doors. There's never many witnesses. It's the things that are said, like, I'm going to put you in a care home if you don't leave anything to me. There's no witnesses, but it scares the hell out of the vulnerable person. And they lose their freedom of thought. And gradually they lose their dependency, and they become very dependent on that caregiver and make their will accordingly. So the language of Section 52 basically reflects the Supreme Court of Canada's language in the Geffen case Geffen and Goodman back in 1991. I have a quote from that at the third page of my paper, going over to the last page of the paper. And in Geffen they said, what then is the nature of the relationship that must exist in order to give rise to a presumption of undue influence? Bearing in mind the decision in Morgan, its critics, and the divergence in the jurisprudence which it has spawned, in my opinion, the concepts are of confidence and reliance do not adequately capture the essence of the relationships that give rise to the presumption. It seems to me, rather than one speaks of influence, one is really referring to the ability of one person to dominate the will of another, whether through manipulation or coercion or outright or subtle abuse of authority. And basically they conclude with, to dominate the will of another simply means to exercise a persuasive influence over him or her. You see, it's not coercion now. It's just persuasive influence. That's a huge change. Proving coercion is almost impossible. You have to have literally a gun to the head and witnesses, witnessing it. But in these positions of domination and vulnerability, it's just persuasive influence. The ability to exercise such influence may arise from the relationship of trust or confidence, but may arise from other relationships as well. The point is that there is nothing per se reprehensible about persons in a relationship of trust and confidence exerting influence, even undue influence, over their beneficiaries. It depends on their motivation and objective to which they seek to achieve. And again, that's an evidentiary matter, but with the presumption, it's a huge factor and a leg up, and I predict there's going to be more undue influence claims and that more plaintiffs are finally going to win. And those are my comments. Does anybody have any questions? Perfect. We have a president's reception. I invite